Hello students. Today we will be considering chapter 8 of Indian Penal Code, which deals with offences against public tranquility. Tranquility means peace. So this chapter deals with offences against public peace. Such offences which are punishable for breaching public peace. This chapter consists of 22 sections, commencing from section 141 up to section 160, including sections 153 capital A and 153 capital B. The offences discussed under this chapter are commonly known as group offences. Such offences are generally committed by a large number of persons, leading to disturbance of public tranquility, harmony, or breach of peace. The offences may be broadly classified into four categories, depending on the nature, gravity, and magnitude of the act in question. The first category is unlawful assembly. The first category is unlawful assembly. Second category of offenses are rioting. Rioting. Third is promoting enmity between different classes. And fourth category is affray. So let's begin with the first category of offenses called as unlawful assembly. Once again, just take a look at the four categories. The first category is unlawful assembly. The second category is rioting. Third category, promoting enmity between different classes. And the fourth is affray. Affray. Okay, so let's begin with the first category, that is unlawful assembly. So what is unlawful assembly? That is defined in section 141. Let's take a look. Section 141, unlawful assembly. An assembly of 5 or more persons. See, the assembly of 5 or more persons is designated an unlawful assembly if the common object, these words are very important, if the common object of the persons composing that assembly is these following: first, second, third, fourth, fifth. So, if 5 persons come together with the common object which falls under any of these 5 categories, that assembly is designated as unlawful assembly. Now, what those 5 things are, let us take a review of them. Let us look at them. First, to overawe by criminal force or show of criminal force the central or state government or parliament or legislature of any state or any public servant in the lawful exercise of lawful power of such public servant. This is one. not difficult to understand. Second, to resist the execution of any law or of any legal process. This is also not difficult to understand. Third, to commit any mischief or criminal trespass or other offense. So if the common object is to commit any mischief, now mischief is specifically defined in Indian Penal Code elsewhere. Criminal trespass is also defined elsewhere in the Indian Penal Code, or to commit any other offense. Now see here, the words are like a residual clause. Any other offense here will have to be understood ejusdem generis to mean an offense of similar kind, that is of mischief or criminal trespass. In one case of Ghansa Singh versus State of Rajasthan, reported in AIR 1958 Rajasthan, page 226, the court held that the word offense in clause 3 is intended to include all offenses both against body and property, and is not restricted only to mischief or criminal trespass. Next, fourth, so if the common object of the unlawful assembly is to take or obtain possession of any property or to deprive any person of the enjoyment of a right to way or of the use of water or other incorporeal right of which he is in possession or enjoyment, or to enforce any right or supposed right by means of criminal force or show of criminal force. So if this is the common object of the unlawful assembly of five or more persons, that becomes unlawful assembly. Or fifth one, again by means of criminal force or show of criminal force, to compel any person to do what he is not legally bound to do. So if a person who is not legally bound to do something is compelled by the assembly of five or more persons by means of criminal force or show of criminal force to do what that person is not legally bound to do. Or take the reverse case, if that person is compelled to omit to do, means compelled not to do what he is legally entitled to do. If this is also the object of the assembly of five or more persons, then it becomes an unlawful assembly. So once again, to repeat, a simple assembly of five or more persons, does not become unlawful. Why? Because, why? You know why? Because Article 19 of the Constitution of India guarantees a fundamental right to form assembly with peaceful in a peaceful manner, to assemble peaceably without arms. But where the assembly of five or more persons possess the common object, which is any of the five categories mentioned here, then that is designated by the Indian Penal Code as unlawful assembly. So this section is basically A descriptive section. This section 141 by itself does not create any punishment. It merely describes when an assembly of five or more persons can be termed as unlawful assembly. Now we come to this explanation part of it. There is an explanation given by Indian Penal Code itself. Let us see what that explanation is. It says that an assembly which was not unlawful when it assembled may subsequently become an unlawful assembly. In other words, an assembly to become an unlawful assembly or to fall in the description of unlawful assembly of Indian Penal Code need not be unlawful since beginning. If five or more persons come together in the beginning peacefully, but later on or subsequently develop a common object of committing any of these five things, then subsequently also it can become unlawful assembly. Not difficult to understand. This section was not difficult to understand, very easy.